Hello everyone, I'm attorney John DeGasperis. I'm the PI guy. Today I want to talk to you about Section 50A of New York Civil Rights Law. This has been a salient issue within the context of the civil rights movement that we have seen here in New York in the wake of George Floyd's unfortunate passing. Specifically, protesters are seeking change and a repeal of 50A of the Civil Rights Law, which permits law enforcement officers to refuse disclosure of their personnel records. This law was enacted back in 1976 when the legislature sought to prohibit criminal defense attorneys from using an officer's personnel file on cross-examination within the context of a criminal case. However, in the year 2014, the Committee on Open Government submitted a report to the governor indicating that the courts had enabled law enforcement to refuse disclosure of materials that in any way relate to personnel records. And so the Committee on Open Government determined that Section 50A undermined the theme of accountability and transparency as set forth and embodied in the Freedom of Information Law. There was really very little discussion about repealing Section 50A until just weeks ago when Mr. Floyd passed. Section 50A works like this. The person seeking disclosure must apply to the court and argue why the officer's personnel record might be relevant to the claims being made within the context of the ongoing litigation. If the court is persuaded that the officer's personnel file may contain relevant information, the court will direct the officer to disclose the personnel record to the court for an in-camera inspection. In-camera meaning that only the judge gets to see the officer's personnel file. The judge alone gets to determine whether the contents of the file are relevant to the issues at hand. If they are, the officer must disclose to the person seeking disclosure. If they're not, the person seeking disclosure never sees the file. The argument is, again, that Section 50A undermines the theme of accountability and transparency as set forth in the Freedom of Information Law. All other public officers and employees are subject to the Freedom of Information Law. They must disclose the records unless one of the few exemptions apply, such as if disclosure would subject the public employee to harassment or subject the public employee or his or her family to harm. So the officers would still have certain protections against disclosure if the circumstances required, but again, it puts public law enforcement on the same level as all other public employees. And so that's the objective of the civil rights movement that we're seeing here in New York. That's all I have on this topic. I wish everyone well, and that's it from the PI guy.